the Ability Center's webinar, Best Practices in Implementing the Americans with Disabilities Act. My name is Katie Hunt-Thomas. I am the Disability Rights Attorney and Director of Advocacy for the Ability Center. I'm going to be introducing our speaker today. Before we get in, I just want to give a brief introduction that the Ability Center hosts a lot of these trainings for ADA coordinators and local governments. This one in particular is part of a two-part series. We're having another one tomorrow at 11:30. That will be a panel of local mayors on accessibility projects that they have done. So I would invite everyone listening to join in on that one as well. We also have an ADA seminar in the fall. This year it will be remote, and I would invite any local or state government officials to join in and get some additional training on the Americans with Disabilities Act. Today, we are lucky enough to have Meg Conger, who is the Director of ADA Compliance for the City of Kansas City, Missouri. Meg has successfully guided Kansas City through a U.S. Department of Justice settlement agreement, working to bring Kansas City into compliance with the ADA Project Civic Access Guidelines and to create and enforce policies to ensure consistent compliance for programs, employment practices, and built environments. She has successfully completed training and passed the exam for ADA certification. Her experience brings years of expertise in the hands-on implementation and planning of ADA transition planning and other Title I and Title II ADA issues, which is something that she will be going into today. Meg is also an annual presenter at the National ADA Symposium, a wonderful training that I would also invite any state or local government representatives that are online to attend. So with that, I'm going to turn it over to Meg. I know we're in good hands. We are going to be taking questions throughout, as she really wants this to be an interactive training. So if you do have questions, feel free to raise your hand or to put them in the chat box, and I will address them to Meg. So go ahead, Meg.
Thank you. And I think it's still morning where I am. I'm in Central Time and where you are. So good morning to everyone. And thank you very much for having me. I'm going to talk today about best practices, also some history about the ADA and some explanation of the different titles. I'm going to have to wear glasses because I have some astigmatism issues, and I am real excited about this. I will be stopping for questions throughout my presentation. I like interactive presentations. I really don't like PowerPoints because I like to have communication between people. So here we go. So July 26th is the anniversary of the ADA. It's coming up. This will be the 30th anniversary of the ADA. As Katie mentioned, we have a National ADA Symposium. Unfortunately, this year it was had to be canceled because of COVID. It was extra disappointing to me because it was going to be held in Kansas City, and I was really looking forward to helping host, but I do recommend it highly. But back to the ADA, it was introduced in 1989 and passed in the US Senate that same year, and then it was passed in the House and signed into law by President George H.W. Bush in 1990. The first set of ADA standards was passed in 1991. And the ADA was broken into 4 different titles. Title I was for employment, and at that time, it affected businesses of 25 or more employees. Title II was affecting state and local governments. Title III affected public accommodations, and Title IV was for telecommunications. So Titles I, II, and III became effective in 1992. Title V was added a little later, and that encompassed miscellaneous things. And many of those provisions, with some of which are found nowhere else in the law, were subsequently included and interpreted by various federal government agencies that issued regulations to implement the other titles of the ADA. And they, under Title V, they require the U.S. Access Board to issue accessibility standards. They allow for attorney's fees to be awarded to prevailing parties in lawsuits filed under the ADA. They require federal agencies to provide technical assistance. They say that states specifically that illegal use of drugs are not covered as a disability. Uh, we'll cover things that are covered as disabilities later. It provides that state and local laws that mandate equal or greater protection to individuals with disabilities are not superseded or limited by the ADA. Title IV became effective in 1993, and Title IV requires that telephone companies provide telecommunication relay services that allow individuals with hearing or speech impairments to communicate using TTY, which is pretty outdated technology now, or other non-voice devices. The Federal Communications enforces Title IV of the ADA. So on Title I, let's talk about Title I and what it means to people with employees, and that became effective back with the original ADA. And what title, oh, Katie, do we have a question? Okay,
I don't see any questions right now.
Okay, I'm sorry, my screen changed, and so I wasn't sure.
Oh, okay.
So let's, back to Title I. What Title I says is that the ADA prohibits private employers and state and local governments and employment agencies and labor unions from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and terms and conditions and privileges of employment. The ADA covers employees now with 15 or more employees. That was changed later from the original 25. So what is a qualified individual? And I'm going to talk about Title I a bit because it's incredibly important, and a lot of people aren't familiar with it because it's tucked away in HR departments, but it's important for everyone to know. A qualified individual is a person who meets legitimate skill, experience, education, or other requirements of an employment position that they hold or seek, and who can perform the essential functions, and that's an important term, essential functions of the position with or without a reasonable accommodation. Requiring the ability to perform essential functions assures that an individual with a disability will not be considered unqualified simply because of an inability to perform the more marginal or incidental functions of the job. If the individual is qualified to perform essential job functions, except for limitations caused by a disability, the employer must consider whether the individual could perform these functions with a reasonable accommodation. Title I issues are usually handled by human resources departments. In Kansas City, we have a committee made up of 2 HR personnel, myself, and we have a lawyer from our legal department to advise us when necessary. An employee who is looking for a reasonable accommodation, and this is how we handle it, requests an ADA, we call it a packet. It's actually 2 sheets of paper. And it has questions regarding the job duties of the employee, what duties they cannot perform due to their disability, their suggestions for a reasonable accommodation, what major life activities are impacted by their disability, and the names of their medical provider. And what is a major life activity as defined under the ADA? Major life activities include, but are not necessarily limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. They do not include driving, which surprises some people. They do not include playing with your grandchildren. They do not include playing softball, and those are all things we have gotten, and other such activities like that. To make sure that our committee partakes in, and this is another very important term, the interactive process, we meet with employees and review their documentation, including their packet, and their medical information, including their diagnosis and prognosis from their medical provider, any restrictions they might have, such as lifting restrictions, bending restrictions, any kind of physical or mental restriction. And then we meet with their management to discuss their job duties and what accommodations would be workable. This is why it's a really good idea for people to have job descriptions, because it's better to have them in place rather than try to make one up when someone is asking for a reasonable accommodation. It is important that both the employer and the employee continue to engage in the interactive process, the back and forth communication of trying to find a reasonable accommodation. If one party ceases to participate, then we close the case. That doesn't happen very often. Engaging in this process is really crucial to finding a reasonable accommodation. You've got to keep those lines of communication open. Not engaging in the process can be a very negative evidence in a court proceeding. We have found that out the hard way in Kansas City. So what are some of the reasonable accommodations that we've put in place for our employees? Because a lot of people overthink these things and make it harder than it really is. We have purchased standing desks, those kind that go up and down, for people with back problems who can't sit for very long or have to get up and walk around when they need to stand. We've had our safety staff, we have a safety staff, perform ergonomic assessments to make sure an employee's desk area is set up appropriately and ergonomically. Their chair's the right height, their computer's set right, they have the right kind of mouse. And so we want to make sure the employee is comfortable and safe. This might result in purchasing a new chair or a special computer mouse, or maybe a footrest to go under their desk. We've added lighting, we've added magnification items, we've purchased larger computer screens, we've purchased software, magnification software for visually impaired people. I just purchased, and I went on Amazon to get it, little lenses for someone's glasses that flip up and down so that when she's on her computer, she can flip down the lenses and it magnifies her computer, and they were $25. So getting a new supervisor is not considered a reasonable accommodation. And we actually have several people who have said, if I just had a new supervisor, I could do my job. Well, that's not a reasonable accommodation. Are there any questions so far on Title I and reasonable accommodations? Okay, we'll keep going. So the COVID-19 virus has brought an entire set of new issues when it comes to reasonable accommodations. There are employees who are individuals with compromised immune systems, I'm sure you've all heard about this, who have doctor's orders to work from home. Sometimes their job allows this to happen. But what happens when the job doesn't allow it to happen? This is particularly prevalent in our financial office when they have to be present to do things like work with checks, work with people's financial information, and it's not secure for that information to go home. So sometimes their job doesn't allow it. Just Monday of this week, just 4 days ago, we had an employee with a health condition and a letter from her doctor saying you need to work from home until the coronavirus threat has passed, and we don't know when that will be. So her management advised the Reasonable Accommodation Committee that the employee could not do the essential functions of her job while working from home. The employee said she could, the management said no, you can't. So we have a problem. The employee assured the committee she could work from home when she filed her packet, and she had medical documentation she should do so. Management said no, so what are the solutions? The employee could use all of her paid leave, vacation and sick time, and see if that would last long enough to get through the pandemic and then return to work, but it likely won't. The employee could ask her employer for an unpaid leave of absence. If the employee cannot afford this, and most people can't, That creates a problem for the employee. If the employer cannot manage without the employee in her position, they might not be able to grant that leave of absence. So the Reasonable Accommodation Committee could make a combination of workplace accommodations that would allow the employee to remain safely at work, and that included placing the employee in an area where she was socially distanced from other employees. And all of our employees are wearing masks, but this employee, that wasn't okay for her. We made sure that she no longer had contact with the public. She had had some contact with the public in her job. We took that away from her job duties. So we revised her job. We bought her, or we are buying her, a face shield because masks were giving her trouble as part of her health issues. So this is a solution we are proposing to the employee and to management, and we're hopeful that both will find the solution agreeable. So you just have to get creative and think about how you can make these things work. Any questions so far? Okay, let's talk about Title II. The Title II of the ADA pertains to state and local governments and prohibits discrimination on the basis of disability in all services, programs, and activities provided to the public, except public transportation services, such as buses. So not only do your buildings need to be accessible to everyone, the programs you sponsor and your activities, such as the ones put on by your parks department or community centers, must be accessible as well. If you have outdoor sports programs, they need to be accessible. Bleachers and concessions at areas that are areas that are often missed. Ice skating classes, we have an ice skating rink where we give classes, they must be accessible to all. Swimming pools must have a lift or a zero level entry to them. Locker rooms, showers, changing areas, those are areas that are often missed and they have to be accessible. We had to do all of these changes in all of our community centers. We're still finishing them up. So this can vary widely at state and local levels because they govern different entities. I have worked with counties and cities across the country. I'll get calls for assistance and they run different things. There was a county in California, they ran the libraries. We don't do that in Kansas City, but this county did. Some run the food pantries and they provide various services. So those all have to be accessible. Polling places are another area where governments often get tripped up, and those also have to be accessible, especially because polling places are often held in temporary places like churches, and a lot of times the older buildings aren't accessible. So those have to be. Okay, I'm going to skip to Title III. And a lot of people here might not think about Title III for your job, but it's still an important feature of the ADA, and I wanted to cover it briefly. So everyone gets involved here. Title III prohibits discrimination on the basis of disability in the activities of places of public accommodation. That includes businesses that are generally open to the public and fall into one of the 12 categories listed in the ADA, and I'm going to go through them quickly. That includes places of lodging, establishments serving food or drink, places of exhibition or entertainment like movie theaters, places of public gathering such as auditoriums and convention centers, sales or rental establishments, groceries, bakeries, hardware stores, service establishments, laundromats, dry cleaners, banks, public transportation terminals, depots, and stations. That includes those facilities, but not the actual public transportation. Places of display, museums, galleries, libraries. Places of recreation, parks, zoos, amusement parks. Places of education, schools from nursery schools, elementary, secondary, undergraduate, and postgraduate private schools. Social service centers such as daycare, senior centers, homeless shelters, food banks, and adoption agencies. And places of exercise or recreation such as gyms, bowling alleys, and golf courses. But what does that mean? Well, it means a lot. It means your business has to have an accessible entrance. That might or might not mean a ramp, but it does mean accessible. Ramps or stairless entries are always a good idea. You have to have accessible routes of travel to get to all the things in your establishment. And that means you have to have clear aisles. They have to be wide enough. People have to be able to get to all the things in your grocery store or your clothing store. You have to have accessible restrooms. You have to have accessible cash registers. You have to have a service counter that's the right height. Restroom compliance is its own topic. I could talk to you about that for 30 minutes.
When we have a question.
Oh, yes, go ahead.
So we have a question about polling places, which is going to be a big topic, I know, coming up in the fall because of all the things going on with the election and it being such a big presidential election as well.
Yes.
So the question is, if a polling place is in an inaccessible building, does it have to be moved? And then what would happen if a polling place was in an inaccessible church?
Was in an inaccessible church?
Mm-hmm.
They would need things they can do to make it accessible. They do need to be accessible under the ADA. Kansas City, Kansas was tagged by the Department of Justice for inaccessible polling places, and that was written into their settlement agreement. You can bring in temporary ramps, but they need to be moved because they do need to be accessible. Does that answer the question?
As far as I know. And then there is another question.
Okay.
And this one I think is referring to Title I employment. So the question is, what accommodations can be made for people with MCS?
I'm sorry, with what?
MCS. And I'm not, if the person who's listening could clarify that, I'm not sure.
Yes.
What that disability is either.
I'm not sure what that is.
Okay. Well, we will wait to see if the person is able to clarify that. And
yeah, if they could clarify that, I'll try to answer it.
Okay, great.
So I'm going to skip over some of the Title III for time because I want to talk to you about some best practices about how to make your spaces accessible. So we touched on the first three titles and
okay, we have a clarification. We have a clarification. It's multiple chemical sensitivities.
Oh, multiple chemical sensitivities. We actually had that in Kansas City with a water employee. If you have multiple chemical sensitivities, we actually purchased a mask. And it was one of the masks that filter. It wasn't just an N95 mask, although we have used those in the past too. But we actually purchased a pretty expensive mask that did filtering. Another thing, if someone has chemical sensitivities and their job involves chemicals and it just doesn't work, what we do then is have them fill out an application for another job. We look at their qualifications, we look at the open jobs, and we try to match them to another position. And we have spent months trying to match people to other positions because we really don't want to have anybody leave because of a disability. It has happened, but we spend months and sometimes over a year trying to match someone. If the person just isn't a fit for that job and can't perform the essential functions because there is no accommodation that can keep them safe, we do try to move them to another position. Did that answer the question?
I believe it did.
Okay, great. So under Title II and III, your entity must be accessible. And there's some easy steps, but it's not an easy task. It's an enormous task. And years ago, one of my best friends told me, we were working on a huge project, and I said, this is going to be like eating an elephant. And she said, well, you know how you eat an elephant? You just start one bite at a time. And if you have a city or county government or any municipality, that's how you have to do it. So the first thing for your buildings, you have to review the floor plans. And you're basically looking for obstructions. And these can be things like width of doors or routes of travel. Pay careful attention to restrooms. Is there room for an ADA stall with the proper turning clearance? Proper turning clearance holds up a lot of people. Is there space for an accessible sink, paper towel, and soap dispensers? I have a really bad habit of when I go to like a restaurant or something. Well, when I used to go to restaurants, we don't do that anymore. But I would go into the women's room, and sometimes I slipped into the men's room to look at the bathrooms. And if I'm with a colleague, an ADA colleague, I would come and say, come in and look at this. This is terrible. And we would look at all the things. And sometimes we'd go to the manager and say, you've got an ADA problem. So it gets in your mind and you can't get it out. But look at your plans. Often, and probably most often, you need an architect to help you look at the plans, find out what's wrong. After you review the floor plans, know your measurements, make a list of action items that need to be addressed. And as you're making your way around, take the measurements, note anything that doesn't meet standards. These are the items that will need to be corrected, and this is how you start making your transition plan. And we'll talk about transition plans. For program access, the process is similar, except you're looking at a program or activity instead of bricks and mortar. When you're making a program accessible, it doesn't mean the accessibility features or access has to be identical to the original program. You are looking for what's called equivalent facilitation. The ADA standards allow alternatives to specified requirements that provide substantially equivalent or greater accessibility and usability as an equivalent facilitation. The question of whether an alternative solution is equivalent involves considerations as to whether it is just as or more effective in terms of accessibility, usability, convenience, and reliability for people with disabilities. For example, the ADA standards specify permanent or built-in features for independent access. So some things for program access are fairly simple. For example, bleachers at athletic fields must be accessible. And this is something Kansas City was really dropped the ball on. We have bleachers sitting out on grass on a football field, very common thing. But if there's not a hard non-slip space for a wheelchair to sit next to the bleachers, they're not accessible. If there's no accessible route to get to the bleachers, like a sidewalk, they're not accessible. And what about getting to the concessions? And what about the ever-present restroom issue? What about the picnic areas and the benches in the park? Are they on concrete pads large enough for a wheelchair? Is there an accessible route? I will never forget the story, and this is something that really drives me. There's a man named Jim DeYoung. He's very, very big in the ADA arena, and he's basically my mentor. He's a wheelchair user, and he was playing, or not, he wasn't playing, he was watching his daughter play on a playground. She was about 5 or 6, and she got injured. And she had fallen and was hurt. And Jim couldn't get to her because the playground had wood chips as their base. And wood chips are not accessible, and they should not be there. And he was horrified and terrified. And he tells that story during trainings, and that story sticks with me. So our Parks Department is eliminating all wood chips and putting in alternative surfaces. Is there a question?
We actually have a few questions.
Okay.
So one person asks, when you've gone to a manager of a facility to let them know that they are not compliant with the ADA, so I think she's talking about your restaurant example, how do you know if they actually ever follow up on your recommendations? And have you ever gone back to check, or how do you know that they've made the change?
I have gone back to check. Sometimes they've changed, sometimes they haven't. I don't file lawsuits and a lot of people do, and I was going to touch on that later. But sometimes they have changed, particularly the parking signs. A lot of people still think, particularly in parking lots, large parking lots for multiple shops, they think if you paint the international symbol of accessibility on the space, that's good. And it's not anymore. In fact, you don't even have to do that anymore. You have to have a sign with the international symbol and it has to be 5 feet from the bottom of the sign to the pavement or the ground. And that's required. And there's parking lots all over that don't have those. And I'll call management companies and say, your parking lot's not compliant. And I've gone back and they've got signs up. And they'll say, well, what do I need to do? And I'll tell them. And so
And you
sometimes,
find that's pretty effective?
yeah, they probably find me annoying, but I'm sure they find me annoying, but I just think they won't change if they don't know. And a lot of times it's just ignorance of the law.
Mhm.
A lot of people will call my office with Title III questions like that. They'll say, do I still have to paint the parking space? And I say, no, you don't have to paint the parking space, but you've got to have the sign. So I think if they're calling, they're going to do it. I hope anyway.
I would hope so too.
Yeah.
Okay. The next question is, does a bathroom stall have to have side grab bars as well as a bar on the back of the stall?
They have to have a side grab bars and a bar on the back, and there cannot be anything above them for 12 inches. And there's so many rules about bathrooms. The toilet has to be 16 to 18 inches from the center of toilet to the wall. We built a brand new building for a police station. We assessed it and found 300 ADA violations. And the contractor and architect and I had a very unpleasant conversation. Mm-hmm. They ended up fixing everything, but the contractor said to me, well, 16 to 18 inches, but what's the allowance? What's my allowance for construction? I said, 16 to 18 inches, you've got 2 inches allowance. Mm-hmm. And they didn't understand that because they're so used to having an allowance.
Right.
And I said, no, that's your allowance. I said, be glad we're not following the 91 standards when it was 17 inches on the nose and you had no allowance. Now you've got 2 inches, be happy. So yes, you do have to have those things. And all of these rules can be found in the design standards at ada.gov.
Okay. In the case of lifts into swimming pools, do private clubs have to have someone on duty to help the person use the lift? And then does that lead to a possible liability issue if something happens when the aid is helping a person into the pool?
Private clubs are exempt.
And what would happen if it were, say, a public pool?
I don't know that question. They need to be trained in the lift. Most people can use the lift on their own because the lifts today you have to have a key to them to start them. And what we do with our new lifts in our pools, they are self-operable. They go and get the key from a lifeguard or from a manager, and then they are self-operable. And our newer pools are zero gravity, but private clubs are exempt from ADA.
As long as the public can't enter, correct?
If they take guests and things, they're still exempt as long as they're a private club.
Okay, there's another question. This one says, could you address service dogs and access to public facilities? And there's an example like restaurants.
Yeah, I've got service animals. I've got 35 or 25 minutes. Oh yeah, we've got a whole thing on service animals. I wanted to talk briefly about the new airport we're building. Kansas City's building a new airport. It's gone from costing $1 billion to $2 billion. I'm not sure how. And we had some interesting things happen with that building. The signage company that was hired to do the designs was in Toronto, and they don't have ADA in Toronto. So they came up with these really cool signage designs, and I loved them, but they weren't ADA compliant. So I got into it with the architects from New York and the signage company from Toronto and the head of the airport who really thought they were cool because they weren't ADA compliant. So they are now. So after a lot of conversation, but you really have to watch if you're working with someone from out of the country, they don't have the same rules. So they don't know the rules. They should know if they're working with an American company or American project. We also are installing a sensory room where people can go to have a quiet experience. A lot of people with disabilities, or not a lot, but some people with disabilities have sensory issues and they just get overloaded, particularly in a busy place like an airport where there's a lot of people rushing around. So we're creating a room, and it's soundproof and it has soothing lighting and comfortable furniture and a window where you can look out but people can't look in. And we limit the number of people in there so it doesn't get crowded. That's something we're putting in for people with disabilities. We're also putting in a large area where it mimics an airplane. It's going to be a simulation of an airplane ride so that people with anxiety about riding on an airplane, children or adults, my sister has horrible anxiety about flying, they can go and have a simulated experience about flying. And we hope that will alleviate their anxiety before they get on an airplane. So those are two things that we're doing in our new airport to help people with disabilities, anxiety, sensory overload, things like that. We're putting in they're called SARAs, Service Animal Relief Areas, according to FAA instructions. And but those are two really cool things that we're doing. I am going to jump over to service animals because I've got a lot on service animals. I had a lot of stuff to talk to you about, but I'm going to jump to service animals because it's a hot topic and there's a lot of information. Okay, so first, the basics. A service animal is a dog, period. It's a dog, except in the few situations when it's a miniature horse. It's always a dog if it's not a miniature horse. If someone comes up with a cat or a rabbit or a snake or a peacock or some other animal, someone did try a peacock once on an airplane, and it claims it's a service animal, it's not. It must be a dog or a miniature horse. There are two questions that you can ask someone with the service animal, and only two. They are, is the dog or horse a service animal required because of a disability? And two, what work or task has it been trained to perform? You cannot ask, well, what's the disability? You cannot ask, well, have him show me the task. Those are the only two questions you can ask. So what are some of the tasks that service animals perform? Some obviously guide people who are blind, alert people who are deaf, pull a wheelchair, alerting and protecting someone who is having a seizure, reminding a person with a mental illness or someone who is diabetic to take a prescribed medicine, calming a person with post-traumatic stress during an attack, or performing a myriad of other duties. They are working animals, they are not pets, and the tasks they have been trained to perform must relate directly to the person's disability under the ADA. Now, this definition does not affect or limit the broader definition of assistance animal, which is where you'll find cats and rabbits and sometimes a squirrel. I've seen so many monkeys, I've seen so many different things. And those fall under the Fair Housing Act. And that's a broader definition. And then the ones that fly, those fall under the Air Carriers Access Act. So those are two different acts, and one governs air flight and one governs housing, dormitories, things like that. Also, some states and localities might define service animals more broadly than the ADA does, and information about those laws and ordinance can be obtained from the state's Attorney General. And these local laws can really mess up the definitions under the ADA. And I don't want to spend too much time on them, but I'll give you an example. Under the ADA, a service dog in training is not recognized as a service animal. However, if a locality decides to recognize a service dog in training as a full-fledged service animal, they can do so. And then that animal would be a service animal and would follow all of the other rules under the ADA. So this can get a little tricky at times because localities can do things like that. So what you can't do with service animals: you cannot ask about the person's disability. You can't require medical documentation. You cannot require special identification. There is no registry for service animals, although there are people on the internet that tell you there is, and if you will send them $100, they will register your dog and send you paperwork. And those are scams, and people are making a lot of money on them. So you can't ask the dog again to demonstrate its ability to perform a task. Some people will say their dog is registered and pull out a card or a piece of paper, and again, they've been scammed. And they get real tricky. Service animals, they're an issue because allergies or fear of dogs are not valid reasons for denying access or refusing service to people using service animals. For example, when a person is allergic to dog dander, and a person who uses a service animal must spend time in the same room or facility, such as a school classroom or a homeless shelter or community center, say it's a shelter for weather or something like that, they both should be accommodated by assigning them, if possible, to different locations within the room or a different room within the facility. You must accommodate both. A person with a disability cannot be asked to remove his service animal from the premises unless the dog is not under the control of the person with the disability, if he's out of control, and the handler does not take effective action to get the dog under control. Also, if the dog is not housebroken, the handler can be asked to remove the dog. When there is a good reason to ask that the service animal be removed, staff must offer the person with the disability the offer to obtain the goods and services that they provide without the animals present. So it can be, you can take the dog outside, tie it up, whatever, and you can come back in without the dog. Restaurants or other establishments that sell or prepare food must generally allow the animals in the public spaces, even if state and local health codes prohibit animals on the premises. Service animals should remain on the floor, and the establishment does not need to offer them water or food or supervise them in any way. Here's another tricky part of service animals. A lot of people's service animals have harnesses on them. Most people have service animal like a vest or something because they don't want people coming up and petting their animal. The animal's working. Most of them are leashed if they're not harnessed, but sometimes they are not leashed, and that's okay, as long as the dog is under the control of the owner. We had a service animal come into our municipal court, and he wasn't leashed. And our security guards went bananas. And they called me and they said, this dog's not on a leash. And I said, is he under the control of the owner? And they said, well, yeah, he's using his, he tells it what to do and he does it. I said, then that's fine. As long as it's under voice or some kind of hand command, he's fine. And what the dog did was he walked pretty far ahead of its owner and did a zigzag walk to clear the path. The owner had PTSD. And when he was too close to people, he had issues. So the dog was clearing a path for him, and he had to go ahead of the person. And that's perfectly fine. But some people freak out when they see a dog without a leash because most laws say a dog has to be leashed. But if that's the task the dog has been trained to perform, it's okay, as long as it's under the control of the owner. So people with service animals cannot be isolated from other patrons. So if they go into a restaurant and they want a table in the middle or the front and the guy says, no, we're going to put you in the back because you have a dog, can't do that. They cannot be charged fees if they go to a hotel and there is a fee for a dog to come into the hotel. They can't be charged that fee. Now, if the dog tears up the room, they can certainly be charged a fee, but any additional fees, they cannot be charged those fees. So that's about miniature horses. The ADA regulations about service animals have a separate provision for these horses that have been trained to do work or perform tasks. And these aren't ponies. These are little horses. They're about the size of they're not even Great Dane size. They're pretty small. They range in height from about 24 to 34 inches when they're measured at their shoulders. I think those are called withers. I used to have a horse, I should know this. And they generally weigh between 70 and 100 pounds. So they're big dog size. So again, they're not ponies, and people kind of freak out and think they're talking about a pony. So entities covered by the ADA must modify their policies to permit miniature horses where reasonable. And there was a miniature horse on a plane not too long ago. In one of my newsletters, they talked about it, and it stood up next to the bulkhead and it was fine. The regulations set out 4 assessment factors to assist entities in determining whether a miniature horse can be accommodated in their facility, because they are still a horse. It's whether the horse is housebroken, because that would be kind of tragic if it were, whether the horse is under the owner's control, whether the facility can accommodate the horse's type, size, and weight, and whether the miniature horse's presence will not compromise legitimate safety requirements necessary for the safe operation of the facility. Pretty vague, open to interpretation. That's the ADA with service animals. They have a lot of interpretation that's open. So since miniature horses have been spotted on airplanes recently, number 4 might be a little difficult to prove and deny entry based on that reason. So you need to document, and document any event and reasons why you denied entry or someone asked with a disability was asked to leave your establishment. Take photos if you can, because people will come back with an attorney and say, I was denied access because of my disability and my service animal. And it's really hard for people with disabilities who own legitimate service animals and that are working and entities covered under Title II and Title III of the ADA to navigate service animal laws and scenarios. Because since no paperwork is required and false registries and paperwork is sold on the internet, and some people are faking it and doing a really good job of it. Remember, legitimate service animals usually do a really good job of letting you know their dogs are working, and they don't want the animals touched, and they don't welcome strangers, especially children who go up to try to play with them. Service animals have been trained to hold going to the bathroom for hours. I was in an airport in Phoenix, and our plane was delayed, and that service animal sat there for 7 hours and then was getting on a 2.5-hour flight, and it was not moving. But with stores like Lowe's and Home Depot allowing people to bring their pets into the stores, it makes it even more confusing because people are expecting to be allowed to take their pets anywhere. Really quick question. I was in a restaurant called I was in a restaurant called Papados in the Houston airport. And there was a woman sitting at the bar, and she had her little dog, and I guess little dogs, on the chair next to her at the bar, feeding him off her plate. And I took a little video of it surreptitiously, and I posted it on Twitter, and I said, does it look like a service animal? Well, Papados messaged me and said, would you please call us? Here's our number. So I did, and they said, what can we do about this? And I said, did you know there are 2 questions you can ask? They didn't even know. So I talked to one of their people and trained them on service animals, basically. They sent me a $100 gift certificate, which I never will go to a Papados again. They're in the South and I won't be able to go. But they just didn't know. And this is a corporation with many restaurants, and they had no clue about service animals. So there's a lot of ignorance about them. So my advice, if a person answers the 2 questions in the affirmative, let them in. Even if you suspect it's not a service animal, it's not worth the possibility of a civil rights complaint being filed against you. But also be very aware that you are in the position to ask the dog to leave if those other situations happen. So you still retain some control of the situation. Are there any questions about service animals?
Well, we had one question, but I think you answered it. It was about miniature horses. I think everybody's always interested in that topic. So
Yeah.
the question was, in what circumstances is a miniature horse a service animal? And you answered that. And that's all. I would just give you a heads up. We have about 10 minutes.
Right,
So,
I saw that. Okay, so let me jump to something that I would really like to talk about, because this is about best practices. And I wanted to talk to you about having an ADA coordinator. And I'm so sorry, there's so much I wanted to go over and I just haven't had the chance. But an ADA coordinator for a Title II entity or a large Title III entity is something, well, under the ADA, Title II entities with more than 50 employees are required to have an ADA coordinator. Some places will say, okay, you're a public works engineer and you're also our ADA coordinator, or you're a human resources employee and you're also the ADA coordinator. And, or sometimes you're a lawyer and an ADA coordinator. Nothing against lawyers, I'm married to one, I love them. But it's a big job, particularly if you're doing a transition plan. And what I do in my position, I manage our training that we do for all employees and new employees. It's ADA awareness training. It's 2 hours long and it was mandated by the Department of Justice, and it's awesome training. I review plans for curb ramps and sidewalks. There are so many that are submitted from engineers that are wrong, so we have to do those. I handle our Twitterati, I call them. And those are people that are very much into walking and they snap pictures of our curb ramps that are wrong and tweet them, and they'll get 400 retweets, and I go out and try to deal with that. I do reasonable accommodations. I'm also our HR liaison to the city manager's department. So I deal with complaints and a lot of other things like that. Hearings, terminations, all kinds of stuff. But when you have a full-time ADA coordinator, and they also work with the public, and I work with advocacy groups. We have a mayor's committee for people with disabilities. They're a great group. I am their liaison. Having a full-time one makes a lot of sense because they are dedicated to that job. They can work with every department within the city. I work with the Parks Department on their issues. They can manage your transition plan. A second on transition plans, what are they? Transition plans tell you what's wrong, how are you going to fix it, and when. And that's the simplest way to describe them. When we did our assessment of Kansas City, we hired an architecture firm to assess every building, every park, every parking garage, everything we had. We had over 44,000 ADA violations. We have to fix them all. Now that's every doorknob, everything, every little thing, but it's a lot of violations and we have to plan to fix them all. So now we have a list in a super duper Excel spreadsheet in a computer program. And we know exactly where they are. We have architectural plans on how to fix everything. We're working on the when because the funding is needed. And I've spent about $60 million. I need about $125 million to fix everything. And budgets are tight. But that's another thing ADA coordinators do. They work with elected officials. They try to find the money. They explain every time the elected officials are different ones come in, they're elected, you have to re-educate them. Hey, we're in a settlement agreement. This is what we have to do, because they don't know, they weren't there. Our settlement agreement is 8 years old. You know, they are new. So I highly recommend a dedicated person to handle all of these issues, work with all the city departments, let them do a complete job. Don't put it on someone else who will work on it a few hours a week, because it is a full-time job if you do it correctly. You've got to have effective communication with the public, with the advocacy groups, within your own city or your own county. I work with other counties and cities across the country. We have a great ADA network of people. We all help each other. We all communicate because there's lots of solutions out there that I haven't discovered yet. And that's how we figure things out. Before my time runs out, because I think I have about 4.5 minutes, does anybody have any questions on anything I've talked about today?
So we did have a question that would be, I think the subject of an entire presentation, but somebody asked about website accessibility.
Oh,
Do websites have ADA compliance issues? If so, are there software programs or companies that I can use to make sure my website is compliant?
let me touch on that very quickly, because the websites do need to be accessible. However, the website rules for that got shelved. But that doesn't mean people aren't suing over website accessibility. They are suing and they are winning. They are going after grocery stores where you can order online. They are going after banks, particularly. There were 11,000 ADA lawsuits in 2017. The number keeps going up. And there are lawyers who love to take them. So website accessibility is very key. If you do any kind of hiring, you need to have people with disabilities be able to apply online. If you have any kind of banking, any kind of business on your website, it needs to be accessible. And there are companies that do that and follow the WCAG guidelines for website accessibility. I imagine that you can find them online, but yes, website accessibility is important. And even though the DOJ shelved them for right now, people are being sued and they are losing their cases. Circuit courts are saying, no, you've got to be accessible. So I highly recommend you get your websites accessible.
All right. Any last questions before we thank Meg for appearing all the way from Kansas City to give a training,
There's one thing I would
Ohio?
like to say, and that is I've been asked by fellow employees, and it just kind of makes me sad. They would say to me, I'm trying to find where I wrote down, they'll say, Meg, we're spending a lot of money on ADA, and don't you think that we're spending a lot of money to help a reasonably small amount of the population? And don't you think it's kind of a waste? And I say, the ADA is civil rights law. It's important. It's about people being treated equally, and it ends discrimination. And what if it were your mom or your dad or your wife or your husband or your child who couldn't get that equal access? Would you want me to make the buildings accessible? Would you want me to make the programs accessible? And then I tell them, don't answer me. Just think about it. And then that's all I say. And I just want people to be in the mindset, what if it were you that needed the access? What would you want me to do? And get in the mindset. And I think that will make a lot of difference.
I love that. Yeah. Thank you so much, Meg, for coming and talking to us.
Thank you for having me.
Yeah, and like I said, the Ability Center tries to foster a network of ADA coordinators in our region. So this is one training among many that we do. We have a couple, every year we do the ADA seminar in the fall, sometime after Labor Day, but we have a couple extra special webinars this year because of the 30th anniversary of the Americans with Disabilities Act. And we always try to bring in experienced experts who can really speak to issues. So, Meg, I think you certainly qualify for that. So thank you.
I'll come back anytime. And if any ADA coordinators want my contact information, please feel free to share it with them.
Wonderful. Thank you so much.
Thank you very much.
And then I would also invite anyone on the call to attend our webinar tomorrow. We're having a mayor's panel of local mayors who will talk about accessibility projects that they're working on. Thanks for coming.
Say goodbye. Thank you very much. Bye-bye.